Hello, my name is Sharon, and I'm a lawyer who's worked with hundreds of seniors navigating debt, financial pressure, and collection threats. If you're over 60 and struggling to stay afloat, you need to hear this, because the truth is there are some debts you can legally walk away from, and nobody is going to tell you unless you know where to look. In this video, I'm going to walk you through 6 debts that seniors often think they have to pay, but actually may not. Some of these might shock you, and they could save you thousands of dollars. So stick with me till the end. And while you're here, like this video, subscribe, and in the comments, tell me, have debt collectors ever threatened or scared you? Let's get into it. 1. Old credit card debt that's past the statute of limitations. Let's really break this one down, because it's one of the most common traps I see seniors fall into. Imagine this. You had a credit card with a balance from 10, maybe even 15 years ago. Life got difficult. You might have had a health issue, lost a spouse, or just couldn't keep up with interest charges. The account went unpaid. You assumed it was done and dusted, but out of nowhere, a collection agency calls you, demanding thousands, threatening lawsuits, and even saying they'll garnish your benefits. Here's what they don't want you to know. Every state and territory has a legal time limit on how long a creditor can sue you for a debt. This is called the statute of limitations. It varies from place to place. Some areas have a limit of 3 years, others up to 6, and a few go even longer. But once that clock runs out, the debt becomes time-barred. That means they can't legally take you to court over it anymore. Now, does the debt technically still exist? In a way, yes. But the power they had to sue you to get a judgment, to garnish wages, gone. And here's the trick that gets people into trouble. If you make a payment, even $5, or say the wrong thing over the phone, you might restart the clock. That's right. Debt collectors are trained to get you to acknowledge the debt just enough that they can take legal action again. So what do you do if someone calls about old credit card debt? First, don't admit anything over the phone. Second, ask for everything in writing. Third, check how old the debt really is. And if it's outside your state's statute of limitations, you can legally refuse to pay and tell them not to contact you again. You are not obligated, and you don't have to live under the pressure of a debt that should have expired years ago. 2. Medical debt that's been written off by providers. Let's talk about medical bills, one of the most painful financial burdens for older adults. You go in for a procedure. Maybe it was urgent. Maybe it saved your life. Then, weeks later, the bills start coming in. Lab tests, anesthesia, hospital stays, follow-ups. You're looking at thousands of dollars, even with insurance. And suddenly, you're being called and hounded by debt collectors. But here's something that very few people know. When hospitals or clinics believe they can't collect on a medical debt, they often charge it off as a business loss. That doesn't mean they forget it ever happened, but it means they may have written it off for tax purposes and sold it for pennies on the dollar to a debt collection agency. Now, here's the key part. You don't owe a debt collector anything unless they can prove you legally owe it to them. That's where many of these cases fall apart. The collector often doesn't have proper documentation. They can't prove you agreed to the specific amount they're asking for. And if the debt is old, it may already be past the statute of limitations, like we talked about earlier. On top of that, some hospitals, especially nonprofit ones, are legally required to offer financial assistance or charity care to low-income or retired patients. But they rarely advertise this. In many cases, you were eligible for help, but never told. So what do you do if a medical bill collector is pressuring you? Request written validation of the debt. Ask when the debt originated. Check if it's been written off by the hospital. And most importantly, don't pay until you know your rights. Medical debt can be terrifying, but a lot of it is built on weak legal ground, and you don't have to cave into scare tactics. 3. Debt held solely in a deceased spouse's name. This is a sensitive one, And I want to speak from the heart here because I've sat across the table from too many grieving seniors who were bullied into paying bills that weren't even theirs. Picture this. Your husband or wife passes away. You're still trying to make sense of the loss, emotionally, mentally, financially. Then the phone rings. It's a debt collector. They say your spouse had a $9,000 balance on a credit card, and they want you to pay it. They'll say things like, "It's your responsibility now." Don't you want to honor your spouse's memory? If you don't pay this, it could go to collections or hurt your credit. Let me be crystal clear. If the debt was solely in your spouse's name, meaning you didn't co-sign or jointly apply, you are not legally responsible for that debt. Credit card companies can try to collect from your spouse's estate, things like savings property or any inheritance they left behind. But they cannot legally demand that you personally pay out of your own income, pension, or savings. Unfortunately, many collectors prey on seniors during this vulnerable time. They rely on your grief. They use fear. They hope you won't question what they say. So here's what you do. Ask if the debt was in only your spouse's name. If it was, tell them, "This is not my debt. You must deal with the estate. Do not contact me again." Keep a written record of all calls. And if they keep bothering you, report them to the Consumer Financial Protection Bureau or your equivalent local authority. You've already endured enough. You are not legally or morally obligated to pay debts that aren't yours. Don't let them convince you otherwise. 4. Federal student loans, including Parent Plus loans, after disability or death. Here's a debt many seniors never expected to carry into retirement. Student loans. You might have taken them out in your 40s or 50s to help your kids go to college. Those Parent Plus loans. Or maybe you returned to school yourself later in life, only to face sky-high tuition. Now you're in your 60s, 70s, or beyond, and still repaying federal student debt on a fixed income. Here's the little-known truth. Federal student loans can be discharged in full if the borrower becomes totally and permanently disabled. That includes direct subsidized and unsubsidized loans, Parent Plus loans, Graduate Plus loans, federal consolidation loans. If you took out the loan and you've become disabled, you may qualify. If it was a Parent Plus loan and the student you borrowed for has passed away, the loan can also be discharged. Even more importantly, if you pass away, your family is not responsible for repaying your federal student loans. They die with you. Now, here's what makes this complicated. Most seniors aren't told about this discharge option. Many believe disability must be proven through Social Security, but you can also qualify through a physician's certification or the VA, depending on your circumstances. And some servicers make the paperwork confusing or fail to inform you of your rights. If you've been diagnosed with a condition that stops you from working, or you're already receiving Social Security disability benefits, you may not have to repay that student loan anymore. Here's what to do. Ask your servicer about the Total and Permanent Disability TPD discharge program. Gather the required documentation and submit your application. It's not automatic. You have to apply. But once approved, your student loan disappears and you finally get a bit of breathing room in retirement. 5. Debt that was forgiven in bankruptcy, but still being collected on. Let's talk about bankruptcy because I've seen a lot of confusion and even illegal behavior from collectors around this one. If you filed for bankruptcy, especially Chapter 7, which is common among older adults, certain types of unsecured debts are discharged. That means they are legally wiped out. This often includes credit card debt, personal loans, medical bills, utility bills, past due rent. But here's the outrageous part. Even after a debt is officially discharged, some collectors will still try to get you to pay it. They'll call you. They'll send letters. They'll hope you don't understand what a discharge actually means. This is completely illegal. Once your bankruptcy case is closed and the discharge has been granted. The debt no longer exists in a legal sense. You are no longer responsible for paying it. Collectors cannot contact you about it. If they do, they are in violation of the Bankruptcy Code's discharge injunction, and you can report them or even sue. Unfortunately, many seniors think, well, they must know something I don't, I should just pay it. But that's what they're counting on. Don't fall for it. If you've filed for bankruptcy in the past and you're getting collection calls on old debts, pull your bankruptcy paperwork, confirm the debt was included in the filing, and tell the collector, this debt was discharged in bankruptcy. Contacting me is a violation of federal law. You've already gone through the hard part. You made the tough decision to start fresh. Don't let shady actors drag you back into debt that no longer legally exists. 6 small balances that cost more to collect than they're worth. Now, let's talk about something a little different, but equally important. Small debts that just aren't worth chasing. We're talking about those under $100, maybe even under $500, depending on your situation and the collector's strategy. Think, a forgotten utility bill from a former residence, a minor cell phone cancellation fee, an unpaid gym membership from 5 years ago, a medical copay you never received a bill for. Debt collectors operate on math. If it costs them more to chase you than the debt is worth, they often don't pursue legal action. Now, this doesn't mean the debt is magically forgiven, but it means they're unlikely to sue. They may sell it to another collector. They might eventually just write it off. So many seniors call me in a panic over a $74 bill they forgot from years ago, worried they'll go to court or lose their pension. But let's be clear. Most companies will not take a senior on a fixed income to court over a $74 debt. It's not worth the legal fees. It's not worth the time. And in many cases, they legally can't collect at all if the debt is too old. What should you do when contacted about a small balance? Ask for proof in writing. Don't panic or rush to pay. Evaluate whether it's past the statute of limitations. Know your income and assets are often protected under senior hardship laws. Many seniors live on Social Security, a pension, or disability, income that's often exempt from garnishment, even in the rare event of a lawsuit. So don't let small debts dominate your peace of mind. These collectors use intimidation, not legal strength. And in most cases, you can walk away and sleep peacefully,